So that's what we're talking about tonight, the shooting death of Jane Creba and this conviction. I'm here with criminal defense lawyer Joe Neuberger. Welcome, Joe. And so much to talk about with this particular trial, just so everybody understands. This was a person who, let's start with one of the most important facts that came out in this case. And that is that JSR did not fire the gun that killed Jane Creba.
That's correct. She was shot by another individual with a different gun.
Right.
Yep.
And that was something that the Crown had to agree with.
Yes.
Justice Nordheimer made that ruling. But at the end of the day, this jury found him guilty of second-degree murder, because the Court of Appeal had earlier said if somebody's at the scene of a frenzied shooting and is taking part in the shooting, he or she can be found guilty of second-degree murder, and that's what happened here. That's
correct. That was the basis, although the theory is a bit difficult, and from what we understand, what we'll get into, there's problems with the evidence.
And let's talk about the evidence, because for him to ever have been found guilty of second-degree murder, the jury was going to have to find as a fact that he was there actually shooting. Whether it was with the gun or not, he was actually shooting. The eyewitness evidence, from what we understand,
the only eyewitness
was apparently so tenuous. Eyewitness evidence, as you know, is terrible and at the best times. It's
fraught with problems at the best of times.
At the best of times. And in this particular case, clearly there was huge problems, and yet the jury still convicted.
Yeah, well, from what I understand from the evidence, this witness was completely inconsistent with description, was inconsistent as to the placement of the individual who he described as shooting. There are problems with the shell casings, which were actually found attributable to the 9mm handgun, which that individual possessed, versus another witness who saw another gun being fired with one shell casing, which the 9 would have matched him, put the shooting at another location, which wouldn't have been JSR. It was just fraught with difficulties, from what I understand.
Well, then let's talk about what could have happened here. And here's a very important principle that happens in our criminal justice system. An accused person is never compelled to testify. They don't have to take the stand. A Crown has to prove guilt beyond a reasonable doubt, and a jury can't make any adverse inferences vis-a-vis the fact that they didn't take the stand.
Correct. The person enters the courtroom not guilty, and they are not guilty until the end of deliberations that say otherwise.
Right. But here is the common sense problem that in all the years I've been in a courtroom, and you have, that you see. In this particular case, the accused was found with a gun in his pocket. The jury knew, or the jury was told, he didn't fire the fatal shots. Yet what the jury was never told, and indeed they came back and asked this question, is how did that transfer take place? Why did it take place? What were the circumstances? And playing Monday morning quarterback or Monday evening quarterback here, with hindsight being 20/20, that perhaps was a fatal, and again, who knows, strategic mistake that accused was not on the stand to explain that to the jury. I can't think of any other reason.
It is probably the most difficult decision that a defense lawyer has to make. And when you look at the evidence in this case, these are experienced, very capable defense lawyers. And when you look at the evidence in this case, one would sit back and think, this is one of those cases where I do not have to call my client. The identification evidence, the only evidence is so bad that I want to sit back and listen to the Crown's argument to the jury first, and then go to the jury last. And that's one of the penalties you get with calling evidence. You have to go first to the jury, and sometimes there's an advantage into waiting to hear what the Crown actually says.